are different interpretations of the Vienna Convention, and based on different interpretations, some say he had immunity, some say he doesn't have any immunity. And when I have at least some opinions, amongst them from international law professors, saying that he had immunity, I have to raise this question in court, and that's what I did. I raised several questions in court, several arguments. The first one is the one about the immunity, which my client should benefit, at least based on some opinions, specialized opinions on this matter. Second one being the question whether a Belgian court in a criminal case is allowed to decide, as the federal prosecutor wants them to, decide that Iranian secret services are a terrorist group, although Iran is not a defendant in this case, only my client and three other particulars are. The third one being a general violation of the defense rights of my client, that is his feeling, and that is what I pleaded in court. And then last, if the court thinks there is no problem with any of those questions, then is he guilty or not, and what would be his punishment? Well, logically, if they decide that they are not allowed to judge him because he benefits from immunity, then they cannot punish him and he has to be released. That would be, of course, the consequence. In this trial, my client is accused of an attempt of terrorist attack in France. So this is what the court is supposed to judge. But because I raise several procedural questions, the court will first have to take a decision on these questions. But if they don't give me right, if they think I'm wrong, then in the same judgment they might say that he is guilty and give him his punishment. That will be in the same judgment. On the other hand, if they say I am right, and indeed he benefits from immunity and they cannot judge him, then this whole procedure becomes impossible. And the reason why he is in prison, being waiting for the judgment of this court based on this procedure, becomes illegal and he would have to be released. The decision of the court regarding immunity only concerns my client. The decision on the violation of the defense rights of my client only is about him. There are two questions that I raised that might involve the other defendants, being the possibility for a Belgian court to decide about the involvement of Iran, because the federal prosecutor says this is a terrorist act because Iran is a terrorist state, and by asking the court to say so, he's asking a Belgian court to decide about Iran being or not a terrorist state, which I'm not Iran's lawyer, but which seems impossible to me. A Belgian criminal court is not allowed to decide such thing. It would be a violation of state immunity, not diplomatic immunity, but the state immunity of Iran itself. Third point that I raised was a general violation of the defense rights of my clients because of the way that he has been arrested, interrogated without a lawyer, all his family and even his kids, minor kids, interrogated without a lawyer, the custody conditions of my client in Germany and later in Belgium, the fact that he was put on a terrorist list, Belgium and EU terrorist list, without having been judged yet, and also the fact that a lot of the accusation is based on information coming from different secret services coming from different countries, which is a type of information that I cannot verify. I cannot see if it's reliable, if it was gathered legally. All these elements put in together give my client the impression that he doesn't receive a fair trial, and that is something that I raised too.